At the beginning of the 1980s, the regular increase in the number of international sports-related disputes and the absence of any independent authority specializing in sports-related problems and authorized to pronounce binding decisions led the top sports organizations to reflect on the question of sports dispute resolution. In 1981, soon after his election as International Olympic Committee president, Juan Antonio Samaranch had the idea of creating a sports-specific jurisdiction. The following year at the IOC session held in Rome, IOC member Judge Kabambe, who was then a judge at the International Court of Justice in The Hague, chaired a working group tasked with preparing the statutes of what would quickly become the Court of Arbitration for Sport. The Court of Arbitration for Sport or CAS, is an institution independent of any sports organization which provides for services in order to facilitate the settlement of sports-related disputes through arbitration or mediation by means of procedural rules adapted to the specific needs of the sports world. It has the task of resolving legal disputes in the field of sport through arbitration. It does this pronouncing arbitral awards that have the same enforceability as judgments of ordinary courts. The CAS sets up non-permanent tribunals, which it does for the Olympic Games, the Commonwealth Games or other similar major events. To take into account the circumstances of such events, special procedural rules are established on each occasion. What disputes are covered under CAS? In principle, two types of dispute may be submitted to the CAS, those of a commercial nature, and those of a disciplinary nature. The first category essentially involves disputes relating to the execution of contracts, such as those relating to sponsorship, the sale of television rights, the staging of sports events, player transfers and relations between players or coaches and clubs and/or agents, employment contracts and agency contracts. Disputes relating to civil liability issues also come under this category, for example an accident to an athlete during a sports competition. These so-called commercial disputes are handled by the CAS acting as a court of sole instance. Disciplinary cases represent the second group of disputes submitted to the CAS, of which a large number are doping-related. In addition to doping cases, the CAS is called upon to rule on various disciplinary cases, violence on the field of play, abuse of a referee. Such disciplinary cases are generally dealt with in the first instance by the competent sports authorities, and subsequently become the subject of an appeal to the CAS, which then acts as a court of last instance. There are three main divisions that handle under the CAS. The Ordinary Arbitration Division, whose responsibility is to resolve submitted disputes to the ordinary procedure, and performs, through the intermediary of its president or her deputy, all other functions in relation to the efficient running of the proceedings pursuant to the procedural rules. The Anti-Doping Division, whose main responsibility is to resolve disputes related to or arising from anti-doping matters as a first instance authority or as a sole instance. The Appeals Arbitration Division, whose responsibility is to resolve disputes concerning the decisions of federations, associations or other sports-related bodies insofar as the statutes or regulations of the said sports-related bodies or a specific agreement so provide. How to begin procedure under CAS? For a dispute to be submitted to arbitration by the CAS, the parties must agree to this in writing. Such agreement may be on a one-off basis or appear in a contract or the statutes or regulations of a sports organization. Parties may agree in advance to submit any future dispute to arbitration by the CAS, or they can agree to have recourse to the CAS after a dispute has arisen. The party wishing to submit a dispute to the CAS must send the CAS court office a request for arbitration in case of ordinary procedure or a statement of appeal in case of appeals procedure, the contents of which are specified by the Code of Sports-Related Arbitration. In the case of the appeals procedure, a party may lodge an appeal only if it has exhausted all the internal remedies of the sports organization concerned. Applicable law. In the context of ordinary arbitration, the parties are free to agree on the law applicable to the merits of the dispute. Failing such agreement, Swiss law applies. In the context of the appeals procedure, the arbitrators rule on the basis of the regulations of the body concerned by the appeal and, subsidiarily, the law of the country in which the body is domiciled. The procedure itself is governed by the Code of Sports-related Arbitration. Costs of procedure. Upon filing of the request, statement of appeal, the claimant, appellant shall pay a non-refundable court office fee of 1,000 Swiss francs, without which the case shall not proceed. The panel shall take such fee into account when assessing the final amount of costs. At the end of the proceedings, the case court office shall determine the final amount of the cost of arbitration, which shall include the case court office fee, the administrative costs of the case calculated in accordance with the case scale, the costs and fees of the arbitrators, the fees of the ad hoc clerk, if any, calculated in accordance with the case fee scale, a contribution towards the expenses of the case, and the costs of witnesses, experts and interpreters. The final account of the arbitration costs may either be included in the award or communicated separately to the parties. The advance of costs already paid by the parties are not reimbursed by the case with the exception of the portion which exceeds the total amount of the arbitration costs. The Court of Arbitration for Sport is a unique arbitration platform created and dedicated to sports and all matters and dispute arising from it, whether commercial or disciplinary in nature.